Suppose the legislature in Wisconsin was concerned about highway traffic accidents caused by motorcycles, and they passed a law banning motorcycles. Would that violate substantive due process?
Personally, I see driving as a privilege. I believe that it is something that you have to be licensed to do, and therefore you should expect to give up some of your rights in order to drive. Therefore, I do not see it as substantive due process I do not see it as an issue of substantive due process if motorcycles are banned from the road.
As seen in anti-federalist paper John DeWitt too, in entering into a social contract, one must be able to give up some of their natural rights in order to preserve the rest of them. And so maybe giving up that right to, or perceived right to ride a motorcycle in order to benefit the safety of the entire public would be beneficial.
I think it comes down to the compelling state interest that the state would or would not have. You have to make sure that the law isn't too narrowly tailored, that it specifies just one type of right that's being taken away from one specific group. But if there's enough compelling state interest, it could pass the scrutiny test.
Okay. You suggested that even if there's a fundamental right to do something, the government may restrict it if there's a compelling government interest. Most of the time, when something's deemed fundamental, it ultimately becomes beyond the government's reach. But very seldom will the court find a compelling governmental interest. And yet we have a number of rights that are not listed in the Constitution. Abortion, privacy, various things that are deemed fundamental. How do we figure out what those fundamental rights are that are not written in the Constitution?
I feel the way to find out what these fundamental rights are to bring your case. If you feel like you have a fundamental right that's being violated, you should bring it to court. As seen in the case Lawrence v. Texas, when the courts ruled that it was the right of privacy that was being overruled, or the government was overstepping its bounds in the right of privacy against two gays. And I feel like if you have a fundamental right that you want to be seen and heard, that you should bring it to the courts.
If I might, that begs the next question, the more important part. How does the court decide what's fundamental?
Justice Harlan said that fundamental rights are rights that are found in the history and traditions of our country, and I agree that fundamental rights have to be rights that you've had for a long time that are deeply rooted within our history, and that you pull those out and decide that these have been around for so long that they have to be upheld at higher than normal rights.
Personally, I would agree more with Warren, who cited evolving standards of decency for deciding which rights are fundamental. Going back to the ratification of the Constitution, not that many people held rights. It's only after time has passed that people have realized how important equality is to society. So I think it's important to see the evolving standards of decency, and I think that's what's really playing a role in struggles for immigration rights and gay rights today.
And what really helps confront the standards of decency changing, we have the 9th Amendment, which specifically states that the enumeration in the Constitution shall not be construed to deny or disparage other rights retained by the people. And so the 9th Amendment is a protection of all other fundamental rights that change throughout time.
So I'm going to switch gears here a little bit and go for, let's say that I want to start an organization of meat eaters, and we don't allow vegetarians, and I receive federal funding for this. Is this a violation of equal protection under the law?
Well, as a vegetarian,
You can join that club.
I would find an issue with it getting the government funding, just because I feel that the government is not really there to promote such things as health or religion, and I do think that when they're causing a meat eaters club, and I don't really understand what the purpose of the federal government encouraging meat eating is. I do not think that there is a state interest in encouraging eating meat, so I don't think it would pass my test.
You all seem to be strongly supportive of the idea of substantive due process, protecting important rights. Is there any downside to our society if courts identify too many rights as fundamental in substantive due process?
Well, that was one of the main arguments of the Anti-Federalists. By creating a Bill of Rights, that we would say specifically which rights are there and which ones are not, and that would suggest that there weren't any.
Yes, the Anti-Federalist paper, Brutus 15, said that the courts would, in a situation of deciding so things as substantive due process would, men placed in this situation would feel above heaven itself, and it really gives them the power to give as many rights as they want. And that's why I agree more with Justice Cardozo and his opinion in Palco v. Connecticut, which they decided not to incorporate the Fifth Amendment. Now, I disagree with not incorporating the Fifth Amendment to the states, but I agree when he talked about the scheme of ordered liberty. There's almost a spectrum. On one side there's liberty, and on the other side it's order. And you need to find the balance between giving people absolute rights and having absolute order.
As you define fundamental rights, let me throw out one, you mentioned Warren, you mentioned Harlan, throw out one other approach. Justice Black said we incorporate the Bill of Rights, nothing more, nothing less. What's the advantage or disadvantage of doing it that way?